Today we're going to talk about the Florida Don't Say Gay bill. That's what everybody's referring to it as. And I want to actually go through the text of the bill and see what it actually says. And then talk about how I feel about it, I guess. So let's skip past the preamble shit and let's just go to the here are the powers and duties that shall be exercised and performed. In accordance with the rights of parents enumerated in these sections, adopt procedures for notifying a student's parent if there is a change in the student's services or monitoring related to the student's mental, emotional, or physical health or well-being, and the school's ability to provide a safe and supportive learning environment for the student. The procedures must reinforce the fundamental right of parents to make decisions regarding the upbringing and control of their children by requiring school district personnel to encourage a student to discuss issues relating to his or her well-being with his or her parent, or to facilitate discussion of the issue with the parent. The procedures may not prohibit parents from accessing any of their students' education and health records created, maintained, or used by the school district as required by this other section. Subsection 2. The school district may not adopt procedures or student support forms that prohibit school district personnel from notifying a parent about his or her student's mental, emotional, or physical health or well-being, or a change in related services or monitoring, or that encourage or have the effect of encouraging a student to withhold from a parent such information. I think that's fair. We shouldn't encourage students from withholding information about themselves from their parents, the people who literally birthed them, generally speaking. Okay? I'm going to make sure that qualifier stays there. This subparagraph does not prohibit a school district from adopting procedures that permit school personnel to withhold such information from a parent if a reasonably prudent person would believe that disclosure would result in abuse, abandonment, or neglect, as those terms are defined in this other section. If a reasonably prudent person would believe that it might result or would result in abuse. That's that qualifier that I was looking for. I think it should probably also be incorporated as an exception within paragraph 1, subparagraph 1, but I appreciate that. Number 3. Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3 or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. There's the problem. So this is just a pure may not occur in kindergarten through grade 3, even if that type of discussion were to naturally arise, and perhaps it is tangentially related to the curriculum somehow. I don't know, because I'm not a part of a school board, all right? And I am not familiar with what the K through grade 3 education standards are at this point. I'm not versed on that. But I do see why people's ears have perked up here, especially when you go, yeah, maybe we grant the kindergarten through grade 3. Maybe it's a little, early on in a child's life at kindergarten through grade 3 to be discussing or instructing children on sexual orientation or gender identity. Okay, maybe that's fair. I think probably the bigger issue is this in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. I don't know what that means. Who is making the determination as to what is age appropriate or developmentally appropriate for any given classroom of students? I see how that entire subparagraph could be problematic because, again, I think I would, and I'm not a parent, but I think I would be okay with just the general notion that at least for kindergarten through grade 3, we probably don't need to be talking about that kind of stuff with children. I imagine, people might argue as to the reasonableness of that exclusion, but that there should be at least some exclusion, probably not too controversial. But the manner thing and what is age appropriate and developmentally appropriate for students is very, very vague. I don't know what it even means. Now, with that said, I also don't know that it is so concretely stated that the uproar about it, to the extent that it is an uproar, is warranted. I think voicing concern, sure. But I think, again, what is likely to happen here is there may be let's say there may be a lawsuit for declaratory judgment by a parent that says, hey, we don't think, we found out that our child was talking in class today about sexual orientation or gender identity, and we don't think it was age appropriate or developmentally appropriate. And maybe the court says, no, actually, it was. These children conducted themselves very reasonably. The discussion was very intellectual and informative, not intended to be manipulative or anything like that. If it's just an informational and educational conversation about these kinds of things, certain kids that are 15 are way more age appropriate and developmentally appropriate to have certain conversations than some 30 and 45 and 50 and 60-year-olds. Like it so largely depends. So I think there's room for further clarification, at least on a case-by-case basis from a court. So while I see that language to be a little bit potentially problematic, I still don't know that the level of uproar is warranted just yet. 4, moving on, finally. Student support services training developed or provided by a school district to school district personnel must adhere to student services guidelines, standards, and frameworks established by the Department of Education. Okay, fine. Throwing that away. Moving on to 5. At the beginning of the school year, each school district shall notify parents of each healthcare service offered at their student's school and the option to withhold consent or decline any specific service. I would need to know what those services are before that sentence means anything to me. Parental consent to a healthcare service does not waive the parent's right to access his or her student's educational or health records or to be notified about a change in his or her student's services or monitoring as provided by this paragraph. That doesn't really do much either way for me. So fine, we just note it. 6, before administering a student well-being questionnaire or health screening form to a student in kindergarten through grade 3, the school district must provide the questionnaire or health screening form to the parent and obtain the permission of the parent. Depending on the questions within the questionnaire, I would say that's okay or that's bad. I would need to see what is actually within the questionnaire. Each school district shall adopt procedures for a parent to notify the principal or his or her designee regarding concerns under this paragraph at his or her student's school. And the process for resolving those concerns within 7 calendar days after notification by the parent. That's what's called an administrative remedy. So that makes sense as well. So basically, you have to give the parent the ability to raise what they consider to potentially be a violation of this statute to the principal, and the principal has to do something about it and provide some response either way as to whether the school believes that they're in violation or compliance with the statute. And then once that determination has been made, if the parent wishes to appeal that determination, then we go to step 2. I'm not sure this specific subparagraph actually makes sense now that I read it again. Each school district shall adopt procedures for a parent to notify the principal regarding concerns. Okay, gotcha. So they shall adopt that procedure and they shall adopt the process for resolving the parents' concerns within 7 calendar days after notification. I don't think this is well written as a matter of grammar or punctuation. I think would be helpful. So each school district shall shall adopt 1, procedures for a parent to notify the principal, and 2, the process for resolving those concerns within 7 days after notification. I think that would clear up my little hang up with how that sentence flowed. And then at a minimum, those procedures must require that within 30 days after notification by the parent that the concern remains unresolved. So that's to say we have to resolve these within 7 days. And if the parent notifies you after 7 days, then the school district must either resolve the concern within 30 days after that, or provide a statement of the reasons for not resolving the concern. And then we go to subsection B. If a concern is not resolved by the school district, a parent may request the Commissioner of Education to appoint a special magistrate who is a member of the Florida Bar in good standing and who has at least 5 years' experience in administrative law. So it's an additional administrative step. That special magistrate shall determine facts relating to the dispute over the school district procedure or practice, consider information provided by the school district, and render a recommended decision for resolution to the State Board of Education within 30 days after receipt of the request by the parent. I think it's interesting that this section doesn't pertain to any information the parent might provide to the magistrate. So it's interesting because arguably the point of the bill is to bring power to the parents, but then at least this initial process of requesting a special magistrate doesn't really concern the information that the parent might have. It doesn't contemplate that at all. That intrigues me. Moving on, the State Board of Education must approve or reject the recommended decision at its next regularly scheduled meeting that is more than 7 calendar days and no more than 30 days after the date the recommended decision is transmitted. Fair enough. The cost of the special magistrate shall be borne by the school district. Fair enough. That could be problematic for the school district depending on budget, but depending on how many complaints come through, we'll find out. The State Board of Education shall adopt rules including forms necessary to implement this subparagraph. Okay, gotcha. 2, this is, again, if a concern is not resolved by the school district, a parent may bring an action against the school district to obtain a declaratory judgment that the school district procedure or practice violates this paragraph and seek injunctive relief. A court may award damages, but doesn't have to, and shall, which means it does have to, award reasonable attorney fees and court costs to a parent who receives declaratory or injunctive relief. So I'm gonna be honest with you, all right? As an attorney reading this statute, and no, that is not an appeal to authority. I see why some areas of this statute could be problematic. But I don't, after reading it, personally feel like the massive uproar coming from the left about this bill is warranted. Perhaps that's because I interpreted something in this statute differently than people who are taking serious issue with it took it. If that's the case, and you think that's the case, let me know. Let's have a discussion about it.